Good evening, guys. Welcome to the grand finale of July extensive series. And today I'm taking you on professional ethics. Topic today is remuneration of legal practitioners and bill of charges. So one of the things you should know when you are going through this topic are I've seen ultra classes are the applicable laws. Already you know your RPC, the recent one. So yes, that's something if you have Andy. Another lesson that you also want to be aware of is the Legal Practitioners Acts. And of course, you know that when you have to do with remunerations, that's like how you get paid, or how you make your revenue, you make money. You also want to know the extant legal practitioners remuneration for legal documentation and other land matters order. There are the documents that prescribe all of these things. And I think if you open your RPC to the last page, scheduled part, you see how they like lay down those fees. So you should after this class, you should make sure that you preview those documents so have better understanding or practical point of view of our class today. So with this said, I've laid the foundation of um of the laws I should know. So in this topic is typically the practical side of or the business side for lawyers because beyond your skills, beyond your money making values, how exactly do you charge? How do you generate income? How do you translate these skills that you've gotten into money for yourself? Because it's one thing to go to your law school, wanting to do an excellent draft, wanting to give perfect advice to your clients, but you imagine you get on a charge. Imagine you don't make the money that you're making is not commensurate to the effort they're putting in. So that's why this topic is very extended. It's something that you should know, like you should really pay attention to before um even beyond law school as a whole, because it's the difference between you making money as a lawyer and you even being an excellent lawyer and making less than your mates. So with this said, what are the factors you should consider when charging? Again, you can look at your RPC to find the particular section that talk about it. However, and because I want the previous one was rules 52, so I don't know the extant one, but around that range where you find it. But what are the factors to be clear? Number one, the skill and labor required to complete the work. So I'm like you're a lawyer, you know the intellect. Is it a niche area of law? For example, if it's maritime, if it's business insolvency, okay, I'm putting this kind of level of skill, this kind of research. Oh, I have colleagues working with me. Or kind of thing. These are things like elements you put to consideration before you just give now charge. So it's not for you to just have a customer that'll just come and just on just give them if so I think that you sit down. That's very good that as lawyers you don't give. And now I'm saying this beyond your notes. As lawyers, you don't just give your client a fee like on the spot sometimes, especially when it's the area you never had template on or done a case for, because that way you have to like sit down with the task and know how much you need to do all of these things. So yes, again, number one, the skill and labor required to complete to work. Number two, the length of time to take to accomplish the task. I don't know if you're familiar with this phrase to say a lawyer's tool of phrase is time. The other don't want to wait is time. Some people will say, okay, if I'm giving you consultation for 10 minutes, 15 minutes, I'm telling you so and so figure. So as a lawyer, these are things you know. Not as someone just come to your DM or your face and then just tell you your ideas. It's your choice anyway, if you just leave it off. But if you want to monetize it and make profits like you are deserving of, these are factors you should put into consideration. So that's item two. Now, what are the third thing or third factors or third factor that I should also know? Again, the complexity or difficulty and novelty of the issues involved. Some issues are rather complex. And I believe, as I mentioned, for that issue, I didn't the maritime issue is really different from when you're dealing with a land transaction. Or in fact, if you even use a land transaction as the base point, or is this person telling me to just buy his land? Is it telling me to just do a corner of sale, or will I do a corner of sale, do a little of assignment, as you keep saying, and now go and do the perfection in the land industry? Is it telling all of this, and then come to have to be the one that mention of the survey plan? Do I have to go to the land registry to check if they don't pre-resisting survey plan? I said on that land, Because those things give you complex, like the nitty-gritty of what you are doing. Or if it's a maritime claim, of course that is a niche area of law. So for example, if you're not a maritime specialized lawyer, but you ask kind of client, oh, do I have to outsource to a listen or facilitate it? Basically you analyzing the complexity of that case as you require, so you know how you will charge. So of course, if you're going to a client for the assignment, it will be different in the way you're charging a client for something that is novel. You get, so those are factors that you consider. Maybe one will be lower, one will be lesser, one will be more. So you can use the case of Peter Obi and INEC in scenario. Again, the number and the importance of document prepared. Some cases require that you use multiple documents. Some not a lot of documents. So for example, if you are doing a large transaction, you're looking at, okay, you're going to do kind of sale, depending on the stage of the transaction that you come in. So you're going to do the kind of sale. If you're going to have a letter of agreement with you and your client, and then you have your date of assignment, you have document A, document B, or you're going to go and meet the land registry, like those are things that you're going to lay out. We are going to use one document. How much do I think I'm going to charge here? Do I charge for a document, the printing? Look, so you must be a businessman if you're going to make money. If you're not a businessman no more, you'll be just doing charity. I'm not saying you shouldn't do it as a lawyer, but I'm just saying that when it comes to the business side of it, you must wear the cap of a businessman. And these are the factors that should take into consideration when you are charging. As a quick distraction, me going to into the RPC, that schedule that talks about lawyers' fees. If it's okay, for example, if you're a lawyer at so level of core, this is what you're supposed to be charging. If you're an SAN, this is what you're going to charge. If you're in Lagos, this is what you're also allowed to charge. So you can see, already they're already telling you that business is, as lawyers should be business minded. So you don't have an excuse, but these are factors that you want to consider also. Because sometimes you just be like, I'm a young lawyer, should I charge? But think about it. Okay, number one, what skill and labor will I put to this work? Number two, what's the length of time that will require to finish this work? Number three, what's the complexity, difficulty, and the variety of issue I'm trying to address? Or is it a landmark decision? I'm telling you many cases that even myself I've been involved in as a lawyer. For example, I don't know if you've checked this online. The Nekonde case it's a recent matter. It's still ongoing, but a part of it has been settled by the Supreme Court. So you can imagine those cases are cases that, for example, the particular one was one that had to be like receivership and it defined the jurisprudence of law. So you can imagine I'm a lawyer on my own and kind of case come to me. What do you think I'm going to do? I'm touching my client. I won't just give them the normal fee. I'm going to give a normal litigation case. No, I'll think about that. Okay, this one is more peculiar. This one is more niche. This one has to deal with more issues, like things that I like sit down with and think of. Okay, this is never been done before in law. How do I get innovative with it? So you can see. So as lawyers don't just charge like a market man. That's like a businessman, like a neighbor man. Like business minded. Again, think about number four. How many documents or what's the importance of the ones I have to prepare. So these are factors I should take into consideration when you are charging fees. I can list even many other ones. Another one is the place of business of where of our transaction. Is it okay? I'm in Lagos where do I have to go to Ilorin? Those are things you should put the question. Number two, another one again is the amount of money or value of property that you are dealing with. The money you charge for a property worth 1 billion, it's not for a property worth 10,000. You get, so even again, this is not exclusive. Even for transactions, some are worth 1 billion. Some people tell you that they charged 5 million naira for legal opinion. Some people say look they gave 25K. Again, it depends on what you are doing and what the value is you see for yourself and make the charge. And that one again is okay, what's the importance attached to that bill by the client? So clients are like, the particular one you don't have fear. You can be like, okay, you think they don't have fear, then it means I have to be more detailed. I'm not saying that you don't rate your clients a little of care and diligence, but I'm saying that sometimes when you see the importance that they attach to the case, you have to even charge further because maybe okay, because with time the urgency I could do this and do that so that you can give them the best output. Another factor you might want to consider also is that a lawyer must consider whether the acceptance with your employment in that particular area will preclude you from appearing in other cases. So this kind of cases happens where conflict of interest can arise. So, for example, if I'm going to represent, let's say, at the case, and maybe I'm already representing, let's say, mobile oil and gas, and I say that okay, if I do that, there's probably a claim that some of them are antagonists in. Will my involvement as a lawyer affect those of both of them? So that focus you should also put into it before take a case before you even charge on it. So that okay, if I cannot do this one, I have to like what outsource it. Um, Another one is on okay, what are the customary charges in that area naturally in our area of law? So for example, maybe it's in CAC, for example, transaction. So people normally charge, let's say, 100K, 150K. Okay, should I charge around that range or should I take my own to 350K? So those are things that you also look into so that you get clientele and you can also build your reputation as a lawyer. And also the contingency of the certainty of the compensation. So there are many factors you consider, but these are some of these that are already alerted for you. So another thing that you want to apply your mind to are the principles and rules guiding bills for solicitor services. So one thing should be clear on is that in land transactions, only lawyers have like the exclusive right to prepare documents of transfer of interest in land. Now I say I have to tell you that okay, you should not collude with other lawyers to do things like many people just sell their lawyers to non-lawyers so they can use and execute transactions. So now you can see that if you're answering the question in your exam, you know that okay, you're paying into you're putting into mind that not only can you use Section 22 of the Legal Professional Act, you can also include the RPC. Talks about not involving non-lawyers. So as lawyers, you don't want to are allowed to issue sanctions of asset transfer of land. So, but of course, if it's about a will, that one's not much collect. It's not exclusive because even the person that is the sector can also do it on his own, and that one is not exclusive. But yeah, something that you should take into account or general rules guiding how lawyers charge. So if you don't participate with a non-lawyer when you're applying legal instrument, I already said it. You can see this in the RPC. You can also see this in Legal Professionals Act in Section 19. So I hope you are following. It's also hard. The lawyer must also receive adequate compensation from his clients. You can see Rule 48 of RPC and the case of GT Bios and another and Udoka and Yamu. Ayamu was in ANYANWU. So as a lawyer, generally you are worthy of your pay. So lawyers too are worthy of adequate compensation. Don't gonna be doing a idea service that you will never gain anything, except maybe you're doing pro bono or it's only thing that's on you. But if you are going to tell your clients, you should put again the business perspective to mind in charging your clients. So that's factors that you put into account as lawyers when you're charging fees. Again, don't be greedy when you're charging your fees. Don't be too high, don't be too low that they can say they are undercutting. Again, if you look at rules 48 of the LPA, it talks extensively on remuneration of lawyers. So the amount of visits after our class. Also talks about in fact most of the points I'm saying right now, if you read Rule 48 of the Legal Professionals Act, you see how they discuss this also for example position. You know that okay, if I know this class rule, I can easily put it across board for many of these factors that I'm writing out. So lawyers should also not fear his fees with non-lawyers, you know, except of course it's money that you're paying for compensation to client to the estate of the client the deceased, I mean, or the family of deceased lawyer for service rendered before his demise, or payment to non-lawyer his employees as retirement plans. Those ones are not really like lawyer money. You get, so you can take that one towards the end of the RPC. Just check it out after the class. Now, there are different kind of fees that lawyers charge. I know you've heard about this before. It's just in your notes. There's something that you call retainer. There's something that you call contingency fee. The hourly fees. They are depending on how you want to call it. But one thing should be clear: The lawyer must charge fees for legal work rendered to his client except his pro bono. And also, the rate of that you are charging as a lawyer should not be excessive. I'm not trying to make gain. It should not be excessive on your clients. So now I'll go to the types of fees I highlighted. So I talk about a retainer. So this is kind of fee you charge a client where both of you agree that they're going to send him for a while. So it can either be a general retainer or a special retainer. It's a general retainer when it's like across board for a particular client. So even if it brings you land matter today, you deal with it. Even if it brings you transactional issues today, you deal with it. But there are also special ones that does have to do with a particular matter. Maybe only comes for maybe only land for a particular case. So you get. So I think this one is like on the surface level. You can easily understand which one is general retainer and which one is special retainer. But of course, if you have questions, please ask. Thank you. So I'll proceed. Where you have in case of a retainer, it's very, very important that you know that a lawyer should not represent a client on an agreed lump sum or fixed fee, because you know that when it comes to retainer, you can never really like prescribe how much you would eventually spend. So giving a person lump sum, what will happen when someone is not even able to fit your fees? So you are generally advised under section that 49 not to give lump sum. So where you accept a general or special retainer, you should you should not advise or appear in any precedents that will be detrimental to your client. So if you are in a retainer with MTN and then you now want to go and appear against them in that case, you get a big conflict of interest, and the rules here is telling you that you should not be found in such transactions. So I hope this explains what a retainer is. You know the meaning of retainer. I know that there are two kinds of retainers. I know that when you are in a retainer agreement, you don't collect lump sums, and you know that also that you should not be in conflict of interest. Again, this is just the next point: contingency fee. So, you really should not accept to enter a contingency fee arrangement where is first advising the client of the effects, and then you should not enter it for criminal cases. So these are things that you should take into account when you are doing your yeah like taking fees like this. And what's even a contingency fee? It's usually a fee that happens on that you charge on upon the happening of an event. Generally, yeah, as much as in common law the is prohibited, but it's permitted under RPC. So you can so just know when and where. But most times they will advise that you shouldn't enter. In fact, the rule as RPC fiscally says that you shouldn't enter contingency fee arrangement without first advising the client of the effect, so that you know that okay, this is what's going to happen to now charge accordingly. And they don't always do this one in criminal cases, because criminal cases are criminal cases. You don't know how the tires return or things in that regimen. We also have scale fees. These are fees that are charged for non-contentious work. So cases that don't usually have like battles. For example, if you look at the RPC, it has how much you should charge for leases, for mortgages. It prescribes some fees. So you can decide kind of fees that scale fees. So like in fact that is like a scale they give you different kind, and you can also find this under the scale 1 and 2 of legal professionals remuneration for legal documentation and other land matters order, which should be strictly adhered to. And it's usually fixed and may not be varied or disputed. And most times court doesn't tamper with this. It just gives you as it is. And that fee you should also put in mind is fixed fee. I think the name is very explained. It's very common amongst especially in consultancy services. So if I'm supposed to say that okay, if I'm consulting for you for 30 minutes, I'm also gonna pay. So that one is something that is very like it's 10 naira, 10 naira, it's 20 naira, 20 naira. So those are like fixed fees. Like as the name implies, that fees that you pick as a lawyer. Let me just use that lawyer so for better illustration, you describe kind of fees, I mean fixed fees, as fees that you fix based on the rate fixed for specific transactions. Suppose some people have money they charge for drafting news, some people have money they charge for um for company registration. So those are like usually fixed fees. So when most time when you fixed fee, you may not want to include, for say when you're doing like litigation, you may not want to include filing fee. So may also have separate concession fee that are already fixed, that are different from their professional charges. So like things you should pay attention to. Another one's appearance fee. It's not very common when you go to court. They'll say, okay, for appearing, some lawyers charge like that. They'll say, if I'm appearing in this case, I'll collect 15K at court, but 20K, depending on how much you want to put, they will charge per appearance. So that's what they call appearance fee. Like the times you charge to cover appearance in court, or that places like multiple courthouses or parliaments, and you only charge regularly by lawyer. Many times that she appears in court, and the amount for kind of transactions like they vary from legal practitioner to legal practitioner. It's also charged in addition to professional fees. So people collect money for litigation on one hand and still collect money for their appearances. So they will charge you like professional fees to file processes and all kind of things. And then on the separate hand, because maybe they don't know how much time you'll be able to appear for the cases, now charge you separate appearance fees. So this is very stagnatory. Another point to note is that there's also hourly fee per hour. Usually common with during conversations you get, and it's in fact it's a very common practice in the US. So there's also percentage fee where you give a particular percentage that you collect for the person as your contribution for a particular matter. So for example, there was a time in my office where I was doing the case, and what we told the client to pay, it wasn't even money. It was to say, okay, um in this case, if you're gonna give us so percentage of the outcome. Maybe for example, it could be the money you gain end of the case or property. So percentage based fee, as basically, oh, one for mini percentage, bye, or you give me a particular percentage. So I say that, okay, oh, fee or showing or Tentayo, you're gonna give me, if as a client you are telling me to do it particular for you and it's worth about 1 billion naira. So what you're gonna give me when we finish it is gonna give me just 10%. So you can imagine some people take payments like that. Sometimes it's even worth it more than just calling out express charges. And it's a very common thing with real estate transaction, because most times it's very more profitable than you just giving them, oh, I'm charging you for the document at 50K. Guy, that's rubbish money. But when you're charging in percentages, know how much you're going to gain. So these are just like many kinds of fees that we have across board. But again, I already explained to you that lawyers, I mean, general principles about the fact that lawyers shouldn't just charge outrageously. They should charge as deserved. They should um you should not shout at outrageous fees. Basically, there are a lot of principles, and they should not charge reduced fees to gain more clients. These are things that can cut undercutting, and the RPC greatly frowns against practices like this. And also, you should also provide for taxation. So sometimes when people are charging you, don't put it that, okay, pay for VAT. Tell us, you know, you're compliant when it comes to tax or regulatory practices. Not charge too low, not charge too high. You can charge based on, although you have to not charge at all when it comes to I mean, in indigency cases, or when person is someone that you know. So these are like general principles and kinds of fees that we have. So there's also a concept that they call the evasion of fees by lawyers. In particular instance, what you should know is that the RPC generally frowns against evasion of fees for legal services. That means you sharing money with another lawyer. They frown against it. But there are instances where the RPC like gives allowances for when you can share money. For example, where you are paying over a period of time to family of the instead of the deceased person. Maybe there's money that is in your custody you have to give somebody. The law allows you. And then maybe it's to for you to do, you can complete an unfinished work for the deceased. They can pay in parts for what has been done. The lawyer who wants to complete the unfinished work of a deceased colleague can pay. Like now, if your lawyer colleague dies, they can allow you to take the money that you should have gotten. But basically, when I finishing the work, you now clear that money on behalf to finish work for him. So in that case, the law doesn't frown against it. Another one is that law firm will also include non-lawyer employees in retirement plan. Of course, they may pay you for that kind of, you're a non-profit, you're not a lawyer, but because you do that administrative tax in the office, you're entitled to your pay. So it's like those limited scope of instances where fees are not allowed. But I would have taken you through this kind of charges, but I don't know which one I'm going to use teach you in your what do you call it? In your this thing. But I'll just go with it nonetheless. I'll just teach you about it nonetheless. Because this topic is not a very long topic, but it's instrumental. So we have about 3 skill charges. We have skill 1, skill 2, skill 3. In fact, after this class, my instruction, admonition, advice is for you to go back to your RPC or that skill charges, that order, and look at it very well so you can see where the one that falls on that skill 1. Because that's something that always comes out in the exam. To be very honest with you, they come out in exam. You will see many past questions on this topic. So you should check it after now. You should go and look at it. You should look at it. It really, to be honest, it really help you. So skill of charges is typically that is that's prescribed. If you look at that scale now, if you look at it now, instead of maybe skill 1, they'll tell you that things like mortgages, leases, you should pay. They won't give you how to access it. For example, they might say that a mortgage, the lawyer should charge full if it's paying for mortgagor, and it's or and then full for mortgage, depending on how it is. But the way is lawyer for both of them. For example, that means when one lawyer asks for both of them, that is entitled to collect full for mortgagee, but half for mortgagor. So just look at it at the scale so that you can know the applicable one that particular question requires of you. Also, at scale 2, they will talk about leases or argument to leases. So just check your book again. These are things that come out to your exam. That's why I'm emphasizing on it. They'll tell you that, okay, if you are the lawyer for the loser, for example, you should collect full. Lawyer for the leasing, that person that is renting, you should collect half. But when you're acting for both of them, can tell you that, okay, pay full for lessor and half from lessee. Sorry, and then 1/4 from lessee. So just look at the bill so that you use the extant portion of law in this particular skill. So you cannot do without looking at lawyers, legal revision order, actually for land documentation. So that you use the applicable skill that's in your this thing. And most times it's this skill you're going to use to compute where they ask you for asking your exam that you ask how much person entitled to. So most times what falls under skill 3 is any other legal documentations that are not like they are legal documentations that are not prescribed under skill 1 and 2. They usually end up under skill 3. So most times skill 1 does mortgages, skill 2 is with leases, and then the other 3 is one. Skill 3 is one that's not described in 1 and 2. So just check your extant so the notion of it is applicable. So most times in skill 3, they don't really pick like specific amount of money, and then but we always advise that you charge a fee that's reasonable. That's reasonable. And like I said before, just to restate, a lawyer is allowed to enter contingency fee arrangement, but it must not be initiated by fraud, mistake, or undue influence, or contrary to public policy. So, but where it involves litigation, it's very important that there is a bona fide course of action. That means that there is a right course of action. So this is typically about what it is when it comes to the examination of lawyers and charges. To be very honest with you, so okay, then I think I should also add the fact that the law allows you to do pro bono services. It allows you to do pro bono services, to pay, to not charge a client or him money, especially any for free, maybe for people that are victims of rape, criminal activities, or maybe because you know the person, as you require your financial member, and you're allowed to do that both in contentious cases and non-contentious cases. What are contentious cases? Cases that has to do with like that you go to court, there's a dispute, and non-contentious alone that there's no, maybe for example, case has to do with interpretation of a law, or that are just purely transactional. So you're allowed either way, but um there is the last typically there's liability in pro bono services. That was Shano. Unless it is excluded by contract. So if you don't do a case where cost pro bono, it does not exclude you from liabilities. And that's what the case of Lawson and Matty says. Lawson as in LAWSON versus Matty METTI. So I think this brings us to the later part of recovery. I mean, remuneration of legal practitioners and taxation. So, as much as you are as a lawyer, you are entitled to collect your money. You also, to collect money. Also, you also have you're also allowed to recover your debt because you did if you do a case and the other, your client needs to pay your money. How will you feed? So, law also takes into account this particular issue, and then it calls such kind of money is recoverable debt. So most of the times when you do a case for a client is supposed to pay your money, and lawyer is allowed to recover these charges from a person. But most of the time, the first step is probably that you should explore ADR. That means alternative distribution. They don't only want they know that you're a lawyer, and it costs nothing to go to court. But they always say that you should first explore ADR because number one, if you go to court directly, it can make you lose that particular client. You get, or it can also like cause a strain in the relationship that you have with the client, that particular client in question. And because if you have a reputation of taking your clients to court if you don't pay money, all other clients also run away from you. So that is why I tell you that you should not go to court first. And again, you know how court can be. It can be a lengthy trial, it can be a torment. So you don't, and again, you don't want to waste resources or energy that will now further dissipate the case or help you with cases that maybe, for example, maybe the money you're owing is like 500K, and then you end up using up to 1 million naira. This it don't make any sense. So you better explore ADR first by saving demands on your line. But anyway, that's step one. Consider ADR first. Step two is that if you consider ADR and it doesn't work, then go to the next phase. And what's this next phase? Is simply to say, okay, I prepare a bill of charges. Again, this particular question about procedure for recovery of personal fees is guided by section 16 to 19 of Legal Professionals Act. So, principal section 16 anyway, but those are the applicable sections. So, you should look at it after this class in detail. So, again, the first step is ADR. Second step for ADR is the number one, you prepare charges that okay, this is how much is pay you're owing me after done ABC and so tax on you. You're owing me so and so amount. Then you serve that bill of charges on your client. So after you check that bill of charges on your client, you allow at least a month to elapse. After which you now commence an action in court legally, officially. You can see in that section 16, section 1 of the LPA. So again, these conditions are mandatory, and if they are conducted, that means they go and you cannot skip one over one. And when you skip one, in fact, it renders the suit for recovery of fees incredibly bad. And who allowed the court decided in FBN and Undoma Egba. Undoma Egba is NDOMA-EGBA. So that's step number one is that you explain here. Number two, your ADR fields consider these three steps. Number one, prepare a bill of charge, start on the client, allow a month to elapse, then now commence your action. So this is typically how to recover monies owed by your clients. Other methods that you may want to consider in covering debts might also be having lien on the money or party or document of the client. If the client has a document, a party that you can place a lien on it for him to pay that amount, after which you can now, regain his property. So the to recover charge through the court, like I already explained, the lot of charges that you would draft, save for the client, allow a month to elapse, and then you now start your official commencement of action. Also, you can, when you're commencing action for recovery of fees, you can commence it by way of petition or an remitting summons in the high court. So usually within 12 months, after that money is not being paid to you. So that's typically the procedure. Serve your client a bill of charge. Prepare a bill of charge, serve a bill of charge, wait for a month. Then any month already elapsed, you can proceed. Okay, so that's typically the process. But I know that you're probably already asking yourself, what exactly is a bill of charge? Exactly, a bill of charge. So I'll explain this to you. A bill of charge is typically a document where you write down the fees that you are owed. You know what a bill is now, or I bill you. As we call it. So you can look at section 19. That's why I said that in this particular part, section 16 to 19 covers this kind of issues. So it means the money you are owed. And what's the purpose of a bill of charge? It's just to help you, want to help the client know what is owing you, and then also it also help tax authorities know how much they would charge that you as a lawyer you pay. I said some lawyers, some offices will tell you that okay, when they're charging their personal fees, they'll put the personal fees and then I'll tell you the rates that you pay according to the national. I think that's about 7.5% percent of what of that actual fee they are charging as tax. So that brings us to section of bill of charge. So a client that disagrees with a bill, normally let me put it this way, when you have a bill of charge, it has a fee. In fact, it's let me start by telling you the concept of a bill of charge. A bill of charge has a particular of the items that are charging for. So what service particularly did I engage in that I want you to pay for? The bill of charge states it. And then after the bill of charge states a particular fee, the bill of charge now tells you other items, maybe professional fees, money for transportation, logistics, everything like that. Then he puts the dates that those things go incurred, and then he now signed the lawyer that gives it. So everything are there. It gives everybody, both lawyer, both tax authorities, the figures to work with. For the part of the client, figure to pay back. For kind of part of the lawyer, money that you collect from the client, then for part of the tax authority, how much is taxable to it. So for taking a bill of charges, the tax authority will do that. Will see it or will log it. For example, if you charge 1 million naira, the tax authority will take some 5% of VAT on that particular transaction. So of course, where a client disagrees with a bill and refuses to pay, it can also apply to the court within 1 month. You get so that they can tax accordingly, and then give him extensions where required. So I think that's typically the particulars of the bill of charge, the heading, the charge, the fee, personal maybe for personal services, for logistics, as much as you like, the money that's the and then that it shows the tax obligation of the clients. Let me give you a case. NEPA and you call me as a case you want to know. They are dealing with taxation of the charges or with charges in general. So you also serve the Your tax means have legal documents. By personal service, that is physically the person that you're giving as a client, or leaving at the client's Latin address, or by post. You can even use a DHL. So just read sections 16 of the LPA and the applicable, the extent portion of the RPC that talk about bill of charges or remuneration of lawyers at the OCO. And you can also keep this case in mind, Abaka and Lawrence. So, like I said before, the time to wait after serving the bill of charges 1 month. If you like a full calendar month, you see that full calendar month under section 18 of the Taxation Act, section 18. So after for that 1 month, you can now proceed to take legal action. But of course, the court can also abridge that 1 month. That means it can shorten it, especially where there's a circumstance that shows that the client is about to do some things, or for reasons beyond his control, he's not able to pay. And the place that you take action to usually the High Court, where the lawyer practices, lives, or does his business. See the case of there are many cases. There's also Ocean Steamship Limited versus Shoti Minu, and also Okenla and Bakari. Like I said before, you can commence the action by writ of someone's position as you want. So, but when a lawyer decides to now bring it through unfunded list procedure, you should ensure that it is with the agreement of the parties. So I think this is basically the idea when it comes to remuneration of lawyers, the taxation. Bill of how to recover fees that you are owed. What is the bill of charge? What's the content of the bill of charge? How do you tack on bill of charge? How long do you have to wait? Which place do you commence the action? So I hope you fully understand this concept now. And of course, if you have any questions, as always, you're very free to ask. I'm going to answer your questions. See you in the next class. Have a wonderful day.